एमाने हेले बरगड़ विकास विरोधी wherein the name of this honorable court has also something which is 43.
This is the first case under WPC 24059 of 2023. Yes, Saurabh Agarwal. My lord, in this case, my lord, the petitioner is in the respective property, my lord, for last 100 years. Okay. My lord may see the ROR and I am the legal heir. My father, it has been recorded in my. That is in respect of your own property. Yes, sir. This is my own property, my father's property. This is a joint family property. My uncle's and my father's name it was recorded. Thereafter, I am the legal heir. Now, my lord, after 100 years, they have just by a like announcement, my lord, they came and they demolished my property, even though there was a stay order was operating on that time window. So, file the contempt. They will file the contempt. Now, my lord, if my lord will see, first of my lord, it is let them file a show cause. They are not filing the show cause, my lord. We'll have it somebody say. File the show cause.
Content that day, it persons be disclosed.
Why? How can it let it go? Let it be there in the list. Which is the contempt, sir? Contempt number. Last item. And the last, the 24059 of department and council the petitioner. Stop. It is stated as the name and council the petitioner that despite the order passed by school, same has been violated, leading to the demolition. Residential building. Yes, my lord. Residential building of the petition, for which the contempt petition instrument number. Contempt. Triple five seven of 2023 has been filed. And the same is taken for orders. Stop Mr. Karan to comment council for municipality place for to find show cause and activated. Stop based on table only from 30th. I mean, pardon. December. My lord, my special launch is my lord, what has happened? Fourth, December. Along with CONT is number 57 of 2023. Then CONT is number 27 into the order in December. Release the matter 4th December 2023. Awaiting response from the party contender. Yes. If there is demolition, then what remains as why status quo? My lord, demolition, other house, residential house. My lord, my first one was demolished. The entire house is there. In the I am that so of course, why should was a status? The petition, the courts earlier order of status social remain was still annexed. Yes. About the other petitions, next one. One of you may address the court, sir.
My lord, I have filed a rejoinder on last occasion. In 12 cases, I am appearing for the petition.
Yes, sir. Sir, we copy the result.
Yes, sir. On last date, I had stopped.
Okay, sir.
Then, my lord, the arguments 24066. 24066. In that matter, I have filed a rejoinder.
Second.
Your lordship, it's a brief letter.
Yes, sir. What is the case, sir?
But here, they have filed a counter affidavit, but none of my cases they have filed the counter affidavit. So rejoinder, in all the cases, what results is your logic that the counter affidavit should be adopted.
Additional affidavit filing. Where is that?
The rejoinder last occasion I had. Is it?
Yes.
Is it there, man?
Yes, yes.
My lord, it is agricultural written note solution also.
Yes.
My lord,
Very detailed.
my lord,
What are the points now? Brief, sir. Yes.
no, no, आज कोर्ट सुनेंगे.
No, sir. We'll close the hearing today, sir.
Sir, dispute is set.
So therefore the argument is done, sir. So
Dispute is set.
there may be some minor differences here and
No,
there. So
my lord, let me say complete highlights.
my lord, I will close that.
Because other repetitions are also.
All the batches of cases.
All batches will get today, sir. Plenty of time. Already. Only 2:30, sir.
Submitted by the municipality. Property are not being included in the demolition list. That was the last time instruction by the.
Sorry, sir.
Mine actually 24476. So my case are not being included in the demolition, but they have given a notice to it without giving so much.
So yeah, sir. It's not in the demolition.
Some cases not going to demolish, but they have filed a petition. But the petitioners can't put to my property.
Okay. Let them will have a hearing, sir. On yes.
12 number cases are short for activity, but petitioners can not read. No.
We'll have a hearing, sir. That's all. You cannot go on like this. I have said last time, this is the final date for hearing. Don't seek for any further action. Yes. Begin, sir.
Yes, sir. But in this case, there are flagrant violations of the principle of justice, as no notice has been given to
Yes.
any of the petitioners, my lord,
Yeah.
prior to taking up the eviction and demolition process, my lord.
Yes.
Also, kindly, now they are saying that we have enforced that. How? Have you demarcated the land? Have you taken any joint measurement of the property before the eviction and demolition? No, nothing is coming forward in the counter affidavit, my lord. Now, your lordship may kindly have a land at Annexure 1. Annexure 1 of the rejoinder, my lord.
Yes.
Well, it's a letter to all the correctors. Yes, to all the corrector is the executive instruction of the year 1989. May I be permitted to read out?
Disposal of encroachment cases, sir.
Well,
Pending encroachment cases to be disposed of.
yes, I am there to say the instruction is putting nahi aata bill. I am there to instruction issued to chief secretary as well as successors that eviction of the should be stopped and new encroachment should be prevented at all instances of encroachment.
Because it credits such objectionable encroachments on the highways. Because the institutes, areas, rocket lands, specific prior permission should be obtained.
Yes. Areas of South rocket land, specific prior permission of the state government should be obtained. Have they filed any in the contract they have obtained specific permission of the government prior to taking up the eviction and demolition process? That is my first.
It is not there according to you.
Yes, my lord. Now, your lordship may kindly have a glance at Annexure A by 2
A by?
of the counter affidavit filed by my learned senior Mr. Mona.
Where is that, sir? In which expedition?
My lord,
In which expedition the counter is?
counter affidavit has been filed.
Common counter. File it.
26017. 26017 WPC. 260.
260. Yes.
My lord, yours what?
Yes, counter.
Counter affidavit in this Annexure by 2.
Yes.
My lord, A by 2 is the complaint based upon which the eviction and demolition process has started.
Yes.
It is a complaint.
Who registered the company?
Before the complaint lodged by one someone.
Yes.
Private sangha.
Yes.
There's a complaint.
Okay.
And your lordship is subject to I'm assisting my senior. But here, your lordship see that annexer. They have filed a counter in my case. In my case, they have filed a counter.
Yes.
In none of the cases, no counter is there.
Same counter is to be adopted.
Yes, sir. Your lordship indicated that.
Yes.
So, your lordship will see it here is Samashri Sangha files complaint.
Yes. Samoleswar Sangha filed the complaint. Based on that complaint, the bottom here lordship says Samir Kumar Pradhan, Sabhapati. एपटे लेखा है प्रशांत कुमार महापात्र संपादक president and secretary of Samoleswari Sangha.
Yes.
Based on this complaint, an inquiry was conducted. That inquiry is at B by 2. B by 2.
Yes.
So B by 2 to the counter. Yes. And after that inquiry, a decision was taken. And subsequently, a notice was pasted at the notice board of the municipality. No personal notice was ever served. What is the difficulty here is that your lordship may kindly see annexure C by annexure 3C. Complaint is Samir Kumar Pradhan and one Prasant Kumar Mahapatra. Annexure 3 series to my rejoinder here at case 30 your lordship would see that in view of the demand of Somerset District Bar Association, a committee is hereby constituted with the following members to inquire into the present status of encroachment of government land from Lengumisara to New Chirati Borough town and suggest remedial measures for eviction. This is the team constituted by the collector.
Yeah.
In the team, your lordship sees 4 and 5. President Bar Association Gorgat, Secretary Bar Association Gorgat. Samoleswar Sangha and District Bar Association are the complainant. They are the member of the inquiry. And the next page, your lordship may see, we had applied for information on RTA. We got the next page 31. In accordance with decision taken in the meeting dated 24/6/23, held in connection with encroachment issues of Borgat Town, the following members from the civil society of Borgat Town are hereby nominated to the committee formed for the purpose as co-opted members. One, Krishna Chandra Panda, second, Pradhan.
Yes.
Your lordship says that no man can be judge of his own cause. Nimo Judge Coswell, that is the principal my lord. They are the companies. They became members of the inquiry committee. They decided to decide the eviction and demolition and the eviction and demolition process will carry.
Yes. Yes.
Now, your lordship may see I have rejoined the rejoinder, I have described everything. The person who have purported representation for working this demolition, I understood from the chapter is for working the road. The person who have purported representation for working of the road as a part of the inquiry committee, as I told now, which culminated into issuance of annexure C by 3. That is the notice pasted in the notice board of the municipality. Even if representation under annexure A by 2 in the counter affidavit is accepted otherwise, my concern is then also the same day the provision of section 44(1) of Odisha Town Planning and Improvement Trust Act. Your lordship may kindly see page 8 of my rejoinder affidavit. Page 8.
Yes.
Petition Municipal State here, section 44 on the 1 of the Odisha Planning and Investment.
Internal base.
My lord?
Internal base.
Internal is 8, my rejoinder, internal is 8.
Yes.
Petition Municipal State here, section 44, 1 of the Odisha Town Planning and Improvement Trust Act 1956 prescribes the procedure to initiate any improvement scheme by planning authority, which is quoted here under. Initiation of scheme. An important improvement scheme within the framework of the allotted plan may be initiated by the planning authority on its own motion, upon a direction by the state government, or C is important matter. On a native representation by 25 or more residents of a ward in the municipal constituted under the provisions of Odisha Municipal Act 1950. So there should be not less than 25 members. The representation should be. Here in this case, your lordship found from the annexer A by 2 of the counter affidavit, 2 persons were the complainant. President Secretary of Samanasar Sangha.
Yes.
Now, pursuant to such representation, a statement of
Committee has not been formed for any improvement schemes, sir. If in case there is a need for improvement, the scheme to be formulated as per the said act, then the same is required to be complied with section 44(1). The committee which has been formed,
yes,
is not for preparation of any scheme.
I'll
The act is that's a request for demolition for that committee was formed. Different than the one which is required under section 40 of the
41. Yes, I could follow you. I could follow your lordship, sir.
yes. What notes, sir? Anything more?
Yes. Pursuant to such representation under Annexure A by 1 given in the counter affidavit, a statement of work is to be prepared by the municipal engineer para 9 year lordship may kindly see.
Are you having an extra copy, sir?
Of this result
for perusal of the court.
Move up to the move. Madam, this is my case.
Yes.
Numerous provisions have been violated. Page para 9, page 10, my lord. The municipal engineer shall furnish annually a statement of work with estimate what to be executed during the ensuing year to the council in time before the preparation of the budget and final section of work. The selection of work rests with the council. All estimates shall be countersigned by the chairman and laid before the council for administrative sanction. A copy of the resolution part therein shall accompany the estimate. A register of estimate and substances allotments have been maintained in form substances.
Yes.
But such statement of work with estimated cost is to be placed before the district planning committee in accordance with 62A(1) of Odisha Municipal Act. Page 9 para 11.
For preparing a scheme as per the said act.
Yes, madam. What up, 62A, I have put it in page 11 here also. It is the district planning committee as constituted under section 62A(1) of the Odisha Municipal Act to frame a scheme in accordance with section 38 of Odisha Town Planning and Improvement Act 1956 by preparing a draft development plan taking into consideration the sufficiency of funds of the municipality in the event the representation submitted by more than 25 residents of the concerned ward is considered to be necessary. Section 62A(1) of the Odisha Municipal Act, I have quoted, there shall be constituted at the level of every district planning committee to consolidate the plans prepared by the Panchayat and the municipalities of the district and to prepare a draft development plan for the district as a whole. Section 38 of the Odisha Town Planning and Improvement.
Next page.
Yes, next. Next, here also see strict schemes. Whenever the planning authority is of the opinion that within the framework of the allotted plan, it is expedient to lay out new streets or alter existing streets, including bridges, causeways, and culverts in any area for the purpose of providing building site, removing defective ventilation, or creating new or improving existing means of communication. We are covered by this C. Improving existing means of communication and facilities for traffic.
Yes.
A scheme is to be prepared, my lord.
That is for laying out new streets or altering existing streets.
Existing one.
Does it apply, sir?
Yes.
Or is it yes?
Yes. So therefore, a scheme is to be prepared before taking up this action, my lord. That is my conception.
It's not in respect of any new streets, sir.
New street
Or alteration of the existing street.
already street is there, my lord.
Street.
Now saying that they are
Section 38 doesn't apply, sir. Only in respect of new streets or alteration of the existing street. It is not a case of alteration. Yes, next.
My lord, next. Skip for you.
The relevant provisions quoted in detail, sir.
My lord, since they have violated all these provisions I have quoted, my lord, so therefore, you lordship may kindly see page 15 of my agenda. Page 15.
Yes.
Bear perusal of the counter affidavit filed by the opposite partner 2 in WPC number 26017 of 23 never disclosed the fact that the municipal engineer has furnished this any statement of work with the estimated cost with regard to widening the road from Lagyu-Misra Chak to Jira River Bridge under Borgat municipality. The scheme of widening the road from Lagyu-Misra Chak to such and such municipality has the approval of the district planning committee, which consists of 16 elected councillors of Borgat municipality and 4 nominated members of the state government. The opposite partner 2 has intimated the state government.
That before any such demolition,
Yes,
a scheme should be in place.
yes,
I got the points.
yes.
What's the right conduct?
some more things.
Yes. Taking it also. Yes.
No.
Yes. Anything more, sir?
Yes. I understand. Therefore, I have vividly described all the here. But so therefore, my contention at para 12 of page 19 of the result is that when a statute describes or requires a thing to be done in a particular manner, that should be done in that manner or not matter. That is the proposition, madam. My proposition. And para 13 year old should may kindly see, I have said that the petitioner motion said that the notification under annexure C by 2 pasted in the notice board of the municipality cannot be treated as a notice for the purpose of eviction and demolition, embracing the accepted principle of natural justice. Thus, in absence of any proper demarcation and exact description of any encroachment, by way of serving a personal notice asking the petitioner to show cause by giving sufficient opportunity of hearing, amounts to abrogation of fundamental right of the petitioner as mentioned in the Constitution of India. And 254.2 in that
Compensation, sir.
Yes.
Mr. Bose was referring to it.
Yes.
But in that same page 20 of my agenda, I've said section 254.2 of Odisha Municipal Act. If the owner or occupier, if the owner or occupier of the premises, as the case may be, proves that any such projection, encroachment, or obstruction has existed for a period sufficient under the law of limitation to give any person a prescriptive title thereto, or that it was erected or made with the permission or license that is not applicable, if any permission or license, the municipality shall make reasonable compensation to every person who suffers damage by the removal or alteration of this. And another provision also I have quoted that under the Motor Vehicles Act, the collector is empowered to streamline that for flying of vehicles from such time to such time, the overloaded vehicles were allowed. And so in that way they can manage also. There was no necessity for demolition.
Yes, anything more, sir?
District planning committee को जोटा कहली से तो हम अच्छी quoted as page 16 16 members of elected in the prescribed manner by and from amongst the elected member of Jilla Parishad and the elected councillors of municipalities in the district in proportion to the ratio between the population of the substances. 4 members to be nominated by the state government as follows: Minister in the Council of Ministers of State, who shall be the chairperson, the collector of the district, the chairperson of Jilla Parishad, chairperson of municipality. एको नहीं गोटे कन्स्टिट्यूट हवा कथा सेमाने करिया कथा कोनोसी किछि न करिकि गोटे रिप्रेजेंटेशन व्हिच वाज गिवन बाय 2 पर्सन ताकू लेके से रिप्रेजेंटेशन को कन्स्टिट्यूट करले दे कन्स्टिट्यूटेड अ कमिटी टेकिंग देम as member and that committee decided for demolition. Therefore it is illegal, arbitrary, and it cannot stand the scrutiny of law.
What is that to add? Madam, I'll just add 2 more things, which my senior has left. Your Lordship may kindly see that counter affidavit. They have filed counter affidavit in 1 case.
26017.
Yes. 26017. That is in my case, they have filed the counter.
WBC number
26017 of 2023. My Lord may kindly see paragraph 4.
yes
That the petitioner is not entitled to prayer made in the writ application because a bare glance of Annexure 1 at page 9 will make it absolutely clear that the schedule plot number 6724 of Mouja Bargad has been recorded in favor of Works Department and the sum of the land is road. Madam, once they say 6724, it is for this confined to this petitioner. They have not made out a case that this 6724 includes all the petitioners.
yes
So once they file 1 counter in 1 case, it should be confined to that writ petition only.
is it the only plot involved, Mr. Panda?
Yes, sir.
Is it the only plot involved, plot number
This is the only plot involved.
because we are referring to para 9 also.
Yes.
For all the cases para 9 also.
In parallel, it should have said.
Plot number is not sure, but the points of launch. Okay.
So, anything means this petitioner who is in which the counter has been filed, 6724, is the only black sheep in the entire bouquet. Means his house will be demolished, not any other house.
It has to be read as with reference to other plots as well. Sir.
No, man.
Only
I'll answer.
but it has to be read with the notice issued to use.
Madam, what is not issued? Where is the notice?
No.
Where is the notice?
Let them complete one. You have it, sir. Yes.
Yes.
Let them complete one by one, not all the council in one time. Okay.
Yes. So, Madam, your Lordship has seen that 6724 of Mouja Bargad has been recorded in favor of Works Department.
Yes.
So, the Department of Works is the person who owns the property, not the municipality.
Okay.
Madam, once it is the government's property, Madam, whether the government has passed an order of demolition or not has to be seen.
Yeah.
Here, municipality has passed the order of demolition. So it is not recorded in favor of the municipality.
Yes.
There is no order of the government of demolition. Then the Lordship will see the committee, which my learned senior has mentioned. Annexure A by 1, Samanasari Sangha has made an application to the Upajilla Jillapad तथा Jilla Magistrate Collector Bargad. There, it was a meeting was conducted, which my senior had stated under Annexure B by 2. And in the meeting, a committee is formed. Now, the Lordship may kindly see the predicament of this present petitioners. The committee is formed. In the committee, who are the members? Member is the government leader, president, secretary of the district bar association, and some other members.
They are the complainant.
They are the complainant. So, they become the committee members to decide the fate of their complaint petition, which has been filed before the district collector. So they become the judge of their own cause. And my lord, one more thing is there. This president and secretary passes a resolution in the bar association that no cases of this person can be filed or no wakalatnama shall be filed of these persons in Burger Court. They become the judge of their own cause.
There's one big petition filed.
Yes.
For the
Your lordship was not inclined to hear. Your lordship.
That's not my assignment.
Yes.
I have to transfer.
That has been challenged.
Yeah.
Now your lordship may see 254(2). If the owner or occupier of the premises, as the case may be, proves that any such projection, encroachment or obstruction has existed for a period sufficient under the law of limitation to give any person a prescriptive title thereto, or that it was
etc. That is not applicable.
That I have quoted in my list.
here, that is the entire thrust. That suppose, my lord, a notice would have been given. Suppose a written notice. We would have filed a show cause. We would have raised the point that this is prior to prescriptive title of limitation.
Yes.
So, my lord, my right to show cause has been curtailed by a mind announcement. Can it be possible? In a democratic country, we are not under the emergency of 1977 that whatever the government will decide or whatever the municipality will do, he will
Yes, sir. Emergency.
whatever they decide, they want to demolish this house, they will demolish
What is
it.
the notice for a notice, sir, as per the municipality act?
Madam, they have to give a notice under 254.
What is that 54?
250, the executive officer makes notice. A 251 one says.
Grant of compensation.
Yes. No, 254 one you're not still mechanism.
One.
Executive officer made by a notice to the owner or the occupier of any premises to remove or alter any projection, encroachment or obstruction other than door, gate, bar or ground floor window situated against it from the such premises.
He said you should indices a show cause.
Notice is required.
That's
The notice is required. What?
very good notice for show cause, sir.
But then your lordship has to harmoniously kindly read 251, 254(1) and 254(2).
To remove the encroachment, that's all.
A notice is required.
Reasonable notice.
Reasonable.
That is individual notice of requirement under the act.
So, my lord, all the petitioners who are before your lordship from the law. 254(2) and 254(1).
You can claim for compensation.
Yes.
On the basis of claim.
Now,
Claiming the possessions of 130. They are not provided in opportunity for
suit, because the suit has their border accusation as state.
Does it let them complete? Because I first have to do one. Okay. That's from the point, sir.
If a notice is issued, if the owner of the occupier of the premises, as the case may be, proves by any such objection. So, my lord, how will I prove? Unless a notice is given, I cannot file a show cause. In some cases, my lord, people have filed a show cause. In my cases, people have filed after getting the mic announcement, they have moved that, please give us notice and please hear us, because we are in possession for more than 100 years. And it has been recorded in the...
What is that in subsection 2, sir? Kindly read it.
Subsection 2 say, if the owner or occupier of the premises, as the case may be,
proves
that any such projection, encroachment, or obstruction has existed for a period sufficient under the law of limitation to give any person a prescriptive title thereto, or that it was erected or made under the permission or license of any municipal authority duly empowered on that behalf, and that the period, if any, for which the permission or license is valid has not expired.
Yes.
Madam, where is the notice that we will file this?
Okay. Next point, sir. What is the next point?
Well, notice describing particular extent of encroachment.
Yes. And moreover, my lord, once they want to demolish, they should first demarcate the land. They should make out a case that yes, this portion of the land is encroaching the road. My lord, my house may be having a certain encroachment or certain projection, but if that projection is beyond the prescribed period of limitation of more than 30 years, I get a prescriptive title over the property.
Yes. Next point.
And Limitation Act will be thrown to the Bay of Bengal. 254(2) will be thrown to the Bay of Bengal by Bengal municipality.
Yes.
They will not give a notice. They will paste in the notice board, backdated, prepared notice was pasted in the notice board. Then, my lord, the entire act is frustrated. The entire demolition process becomes odious in the eye of the law.
Okay, sir. Next point, sir. My lord, my submission with regard to other petitions that I have filed, my lord. My lord, may kindly see the page 10 of which petition, sir? Page 10 of the rejoinder, my lord. Page 10 of the counter, my lord. Counter, right? Yes, my lord. Yes. May see, my lord. The para 1, the action of eviction. Over 58 numbers of ROR have been identified, out of which 39 numbers are recorded in name of Public Works Department, 3 in name of municipality, and 16 under the government's kata. So only 3 has been recorded in municipality name, my lord. Yes. Now, my lord, my submission is this, that, my lord, all those persons who are identified having a ROR, record of rights, published in their name, they cannot be placed under the name of an encroacher, my lord. Either that ROR has to be, my lord, set aside, has to be declared illegal, then only I become an encroacher, my lord. If my lord kindly see a situation, there was a PI filed in Honorable Supreme Court with regard to Jagannath Temple, my lord. So thereafter, my lord, a scheme was formulated. Yes, scheme was formulated for the development of the temple, my lord, and all those lands situated in and around. That's a different scheme, sir. Government scheme. The government scheme was introduced. Now, my lord, the land belongs to government, my lord. Then the ROR are in my name, my lord. For example, I am having an ROR that has to be first discarded under the law. That has to be set aside. Which is the petition, sir? My lord, my writ petitions are that 27. First is 55. The triple fives, first is 24059 of 2023. Yes. That my lord has kept for 4th of December. Then 24938 of 2023. Then 24939 of 2023. Then 24940 of 23. Now, what is with regard to the encroached area, sir? Encroached area, my lord, we have not any question. My lord, my submission is that, my lord, the difference between an encroached area and somebody who is having the right title interest over that property. For example, I am having right title interest over a particular property and it is sacrosanct made by ROR, my lord, then that our disputes with regard to the ROR, sir, that may be in respect to a private plot, but the subject matter is related to if there is a private plot, my lord, if there is a private plot, if that has to be adjudicated upon before a civil court, sir. This is my lord, they cannot say we are entertain such. So, my lord, I am coming, my lord. What I am submitting is that what is in general, in addition to the submission of Mr. Bose and Mr. Monty. My lord, their submission is that there has to be a notice. That is one of the main major. Yes, that is already been submitted by Mr. Monty. Yes, my lord. Yes, my lord. Yes, my lord. What I am submitting is this: if I have a private property, if I am a rightful owner of that property, how can municipality come without any notice, without any case, without unsettling that ROR, they demolish it overnight, my lord?
May I answer your lordship's query, my lord? And Rejoinder page 5, para 5. Rejoinder page 5, para 5. ମୁଁ କହୁଛି ହଁ ସେଇଟା ତ ଗୋଟେ point. But para 5, in para 5, I have described all the petitioners, how they are in possession of the land. And some of them are in possession on the basis of orders filed by Tahsildar Bargarh in different encroachment cases. Some of them are on the basis of ROR. Some of them are there on the basis of judgment and decree filed by Munshi Bargarh, entitled pursuant to title suit, and the others are in possession on the basis of registered sale deed. But we are in possession of the land. Now, if they are saying that there has been enforcement, your lordship is story was that
Any interim orders passed on the suits?
But suit were unable to file.
no, there is no suit.
Yes, must have been on the basis of title.
WPC number 24277, the Gopal Masala case. In this case, the petitioners are in possession of the land
Pursuant to judgment and decree.
dated 16/7/1964,
And which has been confirmed with second appeal. Which has been confirmed.
In which petition you mentioned?
24277.
Para 5.
No, the
Para 5, the result of
yes, my lord. Para 5,
judgment decree 64 passed by municipality.
enter it.
Yes, that is the whole thing.
And my lord, the government filed the second appeal, lost in the second appeal,
Okay.
and not challenged in before apex court.
Municipality will honor the decree, sir. Municipality will honor the decree.
Yes, ma'am.
There is a
My lord,
only 3 number of decree in this. Yes, sir. Yes, anything more, sir? Recorded in the name of municipality.
And in my case, my lord, the RORs in the subject settlement had been recorded and Tahsildar had passed an order settling those lands in favor of the present petitioners. Which settlement has not been questioned by neither by the state nor by the municipality. Not and unless the document is seen in cases individually.
No, individually not possible, sir. You can file a decree note, sir. My lord, see that cannot be individual hearing. After file the notes. My lord, the number of plots in name of municipality. If there is any specific settlement, then it should pending before the civil court or a decree, appeal has been disposed of and dismissed with the confirmation file notes. If there is any specific case. My case, otherwise I will deal with all the general points.
no, para 5 is of the rejoinder I have mentioned so far as my cases are concerned.
Yes.
My lord,
Are those lands that they are asking land that they are saying, they are really recorded in their name? Okay. Anything more?
Yes.
The number of plots have been recorded in municipality. Okay.
My lord, your lordship, annexed 2 have been annexed 2.
Annexed 2?
Of the rejoinder. Page 20.
Yes.
Clarification regarding jurisdiction of Tahsildar to PLE Act
This is the argument today. We'll have it tomorrow.
More
senior and my friend, but once it is brought by their document that 3 plots are against, and in my counter, one plot is against, one plot is in favor of rural department. Thus, municipality that an authority because as per the
Is to reply. Is wait for the reply of Mr. Ponda.
Circular, all lands belong to the government. Even I file
Is to answer, sir. What is the land standard of the municipality? I already some of these plots are in the name of government. Then what is the basis for the municipality to proceed? To answer, sir.
Annexure 2, I was referring to my result at page 20. There, that has been filed by me just to show that the estate officer is only authorized to evict the encroachers from the public premises.
That is referring to OPP.
Yes, my lord. That overrides, the language is, that overrides the provision of section 14 of the Act. Overrides the provision of other Act in respect of matters dealt under this Act. The estate officers are only authorized to evict the encroachers from public premises, and tahsildars have no jurisdiction, even the municipality officer. Therefore, after careful consideration, page 29, it has been decided that all enforcement cases in respect of public premises will now be initiated by estate officers notified under section 3 of OPP EUO Act, and all cases pending before original appellate authority of OPP will now be transferred to original appellate authority under the OPP.
Okay.
Only one more submission here. Yes, to supplement my learned seniors, they vividly argued each and every point. But one thing which comes to my mind is whether the municipality can act the host to Article 300A. 300A may not be a fundamental right; it's a constitutional right and a human right.
Yes.
They have acted what they have done without issuing a show cause to each of the landowners.
Yes.
If I understood, sir, you have completed. Thank you.
Yes, continue.
The court, sir, don't argue with your comment.
Okay, go.
In the recent judgment of the Honorable Apex Court, the episode held that the right to property is ceased to be a fundamental right with the Constitution 44th Amendment.
Yes.
However, it continued to be a human right, a welfare state, and a constitutional right under Article 300A of the Constitution.
Yes.
Article 300 provides that no person shall be deprived of his property save by authority of law. The state cannot
Due process principle. Due process principle will follow.
Yes, Your Lordship. In my case, I have the record of it in my name for last 100 years, Your Lordship. Now, over a night, without any issue, any shocker issue, each and every person, they are just throwing us away out of the way.
Okay.
बुलडोजर हो तो भाग
Anything more, sir? More to add? Okay. Yes.
Deciding this issue,
Yes.
and whether a notice is required or not, my lord, I'm failing my duty in addressing your lordship unless it comes to your lordship's kind consideration that a notice is a mandatory. But suppose definitely. Let me go in other. There's a delay.
Yes.
Municipality has the authority under the city to go to demolish a delay. But suppose a shopkeeper is there who is not the owner, he has a shop. Municipality will come and demolish the dilapidated building, will not give a notice on the 354 to a shopkeeper.
254.
354.
What is there in 354, sir?
254. Now it's 354 demolition.
354. Yes, 354.
Say. No, I'm sorry. No,
354. No, that is. My lord, once they have filed an affidavit, that is counter affidavit, they cannot improve upon that counter affidavit. My lord. Once they have stated that this plot is involved, they cannot say that all the plots are involved.
And surprisingly, they're taking away our constitutional right without even letting us know under which provision of act and rule they're taking such action or recourse.
And my lord, they are not filing individual counter. But in the counter affidavit, paragraph 9, they have said that, my lord, the ancestor of petitioner is in khas possession, my lord. That is not the case, my lord. Okay. Where the RR holder for last 70 years were there, scheduled property, my lord. Improve the case, my lord. Yes, yes.
My lord can see 255.
255.
Yes. The municipality may grant a license. I'm sorry, my lord.
I was also searching for the state provisions.
Yes.
250.
255.
255.
The municipality may grant a license subject to such conditions and restrictions as it may think fit to owner or occupier. You're not saying that this one.
No, this is not with respect to demolition, sir.
Owner or occupier of any premises, verandas, balconies, sunset, weather frame, and lighting.
That is for grant of license, sir.
Sir, this is to project over a road or in roads in which construction of arcades has been sanctioned by the municipality put up a road. But here I want to say, my lord, that even the court in order of over a road, the municipality gives a notice to the grants license to the owner and occupier. My lord, should I not be given a notice to chauffeur? Then my lord, where I can demonstrate to the authorities that
It's not a license, sir. License. Yes. Anything more, sir?
Yes, my lord.
One more thing.
Yes.
The notice of
Okay. Those people who are, madam, according to you, there are certain rights under the Act, yes, which have been defeated in absence of a notice. Yes. So therefore, you are referring to section 55. Okay, sir. And apart from that, my annexure C by 3 is not a public notice, my lord. Okay. Pasted, my lord. Anything more, sir?
On the counter affidavit, when they say that it is one plot,
I will wait for the reply, sir.
Yes, yes, yes. One more.
Yes. Yes, Mr. Panda. Monday will have it on Monday?
Yes, ma'am.
Okay.
But one more case is there.
Yes, yes, special code, pattern, I know procedure. I know, sir. Yes. Monday, sir, 2 p.m.
One more case is there. WPC 24315 of 23.
Yes.
You also kindly look at page 20, annexure 2. That permission was granted by the municipality for construction, my lord.
Okay.
They cannot take away that right. Once they accorded permission and according to their permission, the building was constructed. My building was constructed. They cannot take away by just
Which is WPC number?
WPC number 24315 of 2023, my lord.
Very good permission.
My lord, which is 28, my lord.
Annexure 2. When the permission was in 1976.
Yes, your lord.
What the
And
permission, sir?
valid up to your application dated 30. I am reading that, my lord.
1 year, sir. Validity for 1 year. It has been
Yes, that construct the building. The validity was 1 year. After that, building was erected, and the building is still starting.
The document is not engaging, sir. Whatever, it is valid up to 1 year.
Yes, for the construction process. After the construction process is over, the building is erected, my lord.
Okay.
It is starting and
Okay, sir.
open. Yes, sir, in all of cases.
Okay.
All 6 cases.
Answers for the petitioners. List the matter on 28th November 2020 for further argument.
My lord, I just share one more thing.
Yes.
Not connected to this case.
Yes.
My lord, in Chaudhary Bazar, I was doing one case. There, the owner gave an application to the municipality that my house is dilapidated, you demolish. No notice was given to the tenant because he could not win the eviction suit in Odisha House Rent Control Act. So he gave an application to the municipal court of municipality that you demolish my house. We came up in a writ petition. The tenants came up. The honorable single judge rejected my appeal. we came in division bench. The honorable division bench, today Justice Mahanti was arguing at that time of point of time when he was on this side. There, the honorable division bench said that even if he is a rank trespasser, but he doing an occupation of the building, a notice is mandatory.
That is the settled principle.
Yes.
That is the general principle.
Yes.
No one disputes it, sir.
Yes.
Yeah.
But just by mild announcement or a testamental office,
Here is the
yes, sufficient notice.
general notice, public notice, mic announcement, whether comes. It provides under municipal due notice or not under the notice provides under municipal notice. Satisfied in okay.
Mr. Contact,
সোমবার ভাঙিনি সোমবার দিনে আপনি বিয়ে
Okay, okay, sir.
We are grateful to the Lordship Monday.
Nothing about being grateful, sir.
My Lord, in fact, also the United States of government is grateful to the Lordship. I am stating in open court that due to your Lordship's time interference in the session.
Yes.
I think my senior
Don't make that kind of I don't we have don't make that kind of a general statement. Sir, I don't yes, sir. I got one more statement. We have video recordings that we are showing the order.
they were not mobile.
Contact the contact is fine. See, sir.
And my Lord, think that it is that 77 emergency has come up, that they will demolish what people have joined in the administration, but public
Okay.
once the government, the president bar associations,
Don't make it personal, sir.
they are coming and they are passing resolution that we cannot find the suit.
my lord, I have also a document to show that ସେମାନେ ଗୋଟେ କହିଛନ୍ତି ଏମାନେ ହେଲେ ବରଗଡ଼ ବିକାଶ ବିରୋଧୀ, wherein the name of this honorable court has also
Something which is extraneous should not be brought to the notice of the
Your Lordship, this has content and
code is only concentrated on facts and documents.
how could you place your Lordship's name in the website?
Okay, sir. We'll have it on
Okay, let's see what
Yes, this is the matter on 20th November 2020.
They don't
Okay, sir. Okay.
Hey, dates for the appearance
Sponsor this court address should remain enforced at the next time.
The senior Mr. Ponda is getting for the appearance, so
Yeah, Mr. Dan told me. Oh, yeah, we will be in the case of Gopal. I see that 54টা হিট ফাইল পেলে 54টা কাউন্টার বলা কথা 54টা বিল পাইবে 40 কাউন্টার
Trying to save the expense of the state.
my feeling is not trying to save the expenses. He is saving his money.
Okay.
God bless you.
Okay.
obliged.